Jefferson said this: "You seem to consider the judges as the ultimate arbiters of all constitutional questions, and this is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are no more honest as other men, and not more so. They have with others the same passions for party, power, and privilege of their core. Their power is more dangerous as they are in office for life and not responsible as the other functionaries are to elective control. This Constitution has erected no such single tribunal, knowing that whatever hands confided with the corruptions of the time and party, its members would become despots." So even back then, they understood that this was a great power and one that was easily subject to abuse. And so that was the context. The intent of the framers was to create a limited government, one that would only protect our liberties from those that would take it away from us. It recognized that our own government, our own president, our own representatives would be subject to the same temptations of power and corruption as any man or woman would. So they saw the courts as a bulwark to protect us against that, to get the government off our back, so to speak. And Jefferson had some very wide words, but as a well-known TV psychologist has once been known to say is, "Well, how's that working out for you?" And it's been a very mixed record ever since. The term judicial activism was coined by Arthur Schlesinger in Fortune magazine in 1947, and the name stuck instantly. As you can see, you have judicial review, but then there's the temptation to overreach. You really have two kinds of activism: judicial passivity and judicial activism. Passivity is what we've seen more often than not. Now, you think it's bad when the Democrats control both houses of Congress and the presidency? Imagine what it would be like if they controlled the judiciary. You have a group of people who all are on the same page and will pass everything. And we've seen this happen before. We've seen it now with just two houses. We get TARP, health care, financial reform bills that will be more of a disaster. We get Charlie Wrangle. I mean, you get a whole host of issues. But in the past, when we've seen a single party control all houses, such as during the New Deal, such as during the progressive era in the early 1900s, we start seeing legislation that really doesn't make sense, such as the Gun Control Act of 1934. We see much of the New Deal legislation that would set prices and wages and impose intrusions into it. You see the toleration that allows the Commerce Clause, which was supposed to deal with only a handful of issues, being stretched to encompass anything that could conceivably touch two states. You can see it used in the 1880s tax law to try and get around that. And of course, that ultimately led to them having to pass an amendment, because even tortured justice could not explain the fact that it says no income tax in the Constitution. The Federal Reserve was created in violation of the Constitution in 1916. The Gold Act, which was created as a wartime measure in World War I, was used in the 30s to seize gold and melt it down and outlaw people's right to own non-jewelry gold. I mean, these were things that were not conceived. Taking your money and giving you a fixed price for it was not what was seen in the Constitution. In fact, it was the complete opposite of what was seen. And in those cases, the court sat by idly. That's judicial passivity. And that's because at that time, there were a number of justices who were very much into the progressive movement, who very much believed in the role of government doing good things for people. They had good intentions. They didn't realize that good intentions often have bad outcomes. Then you have judicial activism, which is what we really worry about these days. This is where you're creating rights. This is where you're trying to achieve good things because you're smarter and more noble and you're trying to help your fellow man, and with predictable results, it doesn't work. We know of two laws that I will speak of as examples. One is Roe versus Wade. Now, set aside your ideas as to whether you're pro-abortion or anti-abortion. I want you to think about the law itself. At that time, abortion was illegal in about 26 states. laws on abortion had been on the books for about 100 years. Some of the earliest ones occurred in the 1840s and 1850s. Yet, 5 judges basically sit down and say that the Constitution contains a right of privacy that allows women to get abortions. The phrase that was used, and I loved it when I first heard it, because I actually thought my law professor was making this up, is that there are penumbras emanating from the Constitution that contain implied rights. I thought he was just being colorful, and then I read the decision and actually saw, oh my God, this is true. They were creating these rights out of thin air. They forgot that all of our rights already exist as a gift from God by virtue of our existence. They thought the Constitution was handing you these rights, not the other way around. And even more silly is they didn't just say abortion is legal or abortion is illegal. They didn't say you have a right to abortion or you don't have a right to abortion. That would have been bad enough. What they said is, and here's how you define the abortion right. You can't get an abortion in the first trimester because we, the state, don't have a compelling interest in fetuses in the first trimester. But we do have an interest in limiting abortions in the third trimester because we do have a compelling interest in unborn fetuses in the third trimester. They were literally defining when you could or could not get an abortion, why the state could intrude into that sort of decision making. That's pretty abhorrent. And as I said, it doesn't matter if you're for abortion or against abortion. The key here is who makes that decision? You, legislators, voters in a referendum, or 5 guys, hopefully like me in a black robe, who think they know better than you. The most outrageous version of this is the Missouri versus Jenkins case. This is the Kansas City school case for those of you who keep up with it. And this was where Judge Russell Clark thought there was segregation and racism in Kansas City schools. And so a judge, ordered the legislature and the school board to spend $1.6 billion over a 20-year period to improve the schools. He ordered the local government to increase property taxes by 91% to pay for it. He, not an elected body, created and implemented a plan to expand the schools and build Olympic-sized swimming pools and theaters and museums at great cost. He, a single judge, took the role of a school board, of their equivalent of a county commission. He even tried to order the state of Missouri to increase its sales tax by 25%. Fortunately, that one got knocked down early, but it took 20 years to end this madness. And here's the thing. With all that, with all his great knowledge, basically nothing changed in Kansas City schools. They remained about the same. My relatives who lived in Kansas City schools all decamped to the local Catholic school because it was a much saner environment for them at that time. That's judicial activism. Now, you've all heard this, and it's all nice to talk about things like, gosh, we hate judges and those elitist bastards, they're trying to impose things on you. But here's what I'd like to sort of end on, which is, why do we have judicial activism in this country? We really don't see this much in England and Germany, France, Japan, Australia, any place with a Western-style rule of law, whether it's the civil code or common law. We don't see the courts being used as an instrument of social policy. And here's the reason. You remember when I said that John Marshall said we can only hear things that are brought before the court, and that you can only talk about things that are contained within that scope of work contained in Article 3? Well, if you're going to be a judicial activist, you need stuff brought before you, and that means you need a lot of litigation. And for good or ill, and I won't go into the history behind it, we have 3 things in this nation that make litigation happen a lot. Specifically the kinds of litigation that get you in front of a judge that will be a judicial activist. And also give us the same problems we have with too much litigation in terms of health care costs and insurance costs and things of that nature. First off, we don't have a loser pays rule. Second, we allow contingency fees. And third, we have public interest legislation. Just to go over them briefly. Now, loser pays, known as the English rule, which I like better than the loser pays rule, means that if I take someone to court and I lose, I'm liable to pay most or all of their legal fees. And if I win, they are liable to pay most or all of my legal fees.